Hello and welcome to the Heir Waves podcast, a show about all things wills, estates and succession law in Australia. Your hosts, Kate Brewer, succession law barrister extraordinaire, and Michelle Davis, lawyer, educator and succession nerd, have a mutual love and deep interest in all things succession law. In this podcast, Kate and Michelle share stories, thoughts and considerations of wills, estates, trusts and succession case law from around Australia. Join us on the Heir Waves for all things succession law and be sure to subscribe and follow the podcast for all the latest episodes. Please know that the information provided in this podcast is for general information and educational purposes only and should not be construed as legal advice under any circumstances. Please get specific legal advice for your particular circumstances. Any views or opinions expressed by our hosts or any of our guests are the personal views of that person and are not representative of their employers or any organisations or bodies of which they are affiliated.
Hello, I'm Kate Brewer.
Hello, and I'm Michelle Davis. Welcome to the Heir Waves podcast. For our first episode, we've chosen two cases that we found really interesting. One involving a gift that is mutual wills and another involving a family provision claim by an adult child with accusations of disentitling conduct. Firstly, we're going to start with Kate to introduce our first case. Over to you, Kate.
Thanks, Michelle. The case that I wanted to discuss on mutual wills is only handed down this week by Justice Ryan of the Supreme Court of Queensland. The case name is Forster and Forster, and a full citation will be in the show notes. It was a case about mutual wills. As Michelle says, it is a gift that keeps on giving. It keeps estate litigation lawyers, the concept of mutual wills keeps estate lawyers very busy. And it's a topic that causes great angst among succession lawyers and particularly their clients. I do have to disclose here that I acted for the respondent in the case, so I will attempt to keep it as unbiased as possible and objective. In this case, the applicant, James, was one of three children of Timothy. Timothy was married to Annabelle, who was the respondent, who herself had two children. Both of them were from prior marriages, and that was the second marriage for both of them. Tim and Annabelle entered into a mutual wills agreement where, in summary, they agreed to make wills leaving everything to each other and then, upon the death of the survivor, to the five children equally. That really is an oversimplistic summary of the agreement, but it's sufficient for our discussion today. The agreement was in writing, which, of course, a mutual wills agreement doesn't need to be in writing. It can be oral, and cases have succeeded with oral agreements, but obviously it is preferable if you are entering into a mutual wills agreement to make it one that's in writing. Tim died first. James, who was, as I mentioned, a son of Timothy, distrusted Annabelle immensely. He wanted Annabelle to disclose to him what her assets were, and he wanted her to continue to give him yearly summaries of what her assets were, in effect, so that he could keep tabs on her in case she tried to gift away anything to her own children or to others that might affect his ultimate inheritance. Annabelle refused to do so and said that information was her confidential information. She had no obligation to have to share it with him, being her stepson who openly hated her. She made it clear that she considered herself bound by the mutual wills agreement and that she did not intend to breach it. James brought an application to court to force Annabelle to disclose her assets to him and to force her to continue to do that on an ongoing basis. In an open letter that was before the court, James's lawyers told Annabelle that they were determined to force her to make full and complete disclosure, as well as an ongoing disclosure, to ensure that the rights of James and his two siblings were protected. The basis of James' application was that because of the mutual wills agreement, Annabelle was a trustee of all of her assets that she now owned, on the basis that upon the death of Timothy, a constructive trust arose, and so she now held those assets on trust for him and the other children. The application was made pursuant to Section 8 of the Trusts Act in Queensland, that is. Annabelle defended the application on the basis that she was not a trustee and that no trust arose upon Tim's death or at all unless and until she breached the agreement and the court, by way of a remedy, imposed a constructive trust. The judgment is a pretty long one, being 43 pages. It's a very good discussion and lengthy discussion about the nature of obligations of persons who enter into mutual wills agreements. The judge ultimately agreed with Annabelle's submission that a constructive trust is remedial, and that no trust arose upon Tim's death or at all unless and until it was ordered by the court. So, Shell, from an estate planning perspective, how does this case speak to you?
Yeah, look, I think this is a really interesting case, Kate, because from a planning perspective, I can't help but ask questions like, expectations and managing expectations kind of thing. You think about client coming into you and having these queries about disclosing information about mutual wills and everything. And I think there might be a fair amount of misunderstanding or just lack of understanding about mutual wills, really, in the general public. So it kind of, you want to kind of talk to them about that expectation of what it actually means to be the family on the receiving end of a mutual will when the first person passes away. What do you think? Do you reckon that could have been more of a just that misunderstanding of what it actually means to be a party, or a distinct party perhaps, to a mutual wills agreement?
A potential beneficiary of one might be a better description. Definitely a misunderstanding out there. I think there's a misunderstanding out there amongst lawyers as to what people's obligations are and what's the actual legal status of such obligations. This case of itself is a good example of that. It's complicated law. It's not something that's really easy to grasp. And there's even comments in certain cases and articles written by relatively learned people to the extent that a trust does arise in these circumstances. And so it's quite difficult to get your head around the legal concepts of it. So
and that's
arguable.
For a lawyer. Yeah, arguable. And that's the whole point, isn't it? That's why we're talking about it.
And that's for a lawyer who, that's for lawyers who've been involved in the legal profession for many, many years. So of course, for lay people, it is going to be quite complex, the issues involved. It's interesting because I think the concept of a mutual will is one that's really appealing to people who might be in second marriages and both have children, etc., especially where there might be unequal, assets between the two, somebody who's quite wealthy and somebody who's not, or differences in ages of people. But certainly as an estate litigator, as I said before, these kinds of cases are really rife for disputes, about what the terms of certain agreements are, whether there are agreements at all, let alone what the terms of them are. So,
and I think from a planning perspective, there's certainly a number of people that either love or hate them. And you can understand why. They are complex beasts without question. And I think this case certainly highlights that. It also highlights how much technicality there is when you talk about the fact that the judgment is a brilliant judgment to look at in terms of the summary of the issues that the court had to consider, and the background of mutual wills in judicial consideration. And even there was a paper by Justice Lemire that was also referenced in the judgment, which I actually remember reading. In fact, I was there at the STEP conference when he delivered it. And it really speaks to that complex nature of mutual wills generally. And I know from when I'm sitting in front of clients that are in blended families, multiple relationships, kids to different parental groups, that kind of thing, it's tempting to want to go down that road 100%. But at the same time, you've really got to give the client that warning that these are complex documents and they are not. There's certainly not one size fits all, that's for sure. But sometimes they are possibly more hassle than they're worth, and there's a level of risk that the client might want to take on about that whole concept. But it's a difficult one, and I think there's you're going to find people in different camps on the question of whether mutual wills are the best outcome or not to a concern about managing obligations across different family groups.
Exactly, because when you have that that blended family, or whatever the situation is. I see mutual wills mostly in blended families, but of course that's not the only use for them. But it's mostly the ones that come across my desk involve blended families. If a family's going to be litigious, it may not matter what estate planning tools you put into
That's
effect.
right.
It might just end up in litigation anyway.
Exactly.
So
you can
who knows?
best laid plans and all that. At the end of the day, it
Yeah.
can still end up in court, which is a sad fact of litigious nature of estates work these days, I think.
Yes.
Yeah. But no, look, it's a fantastic case, and I'm glad you raised it because, it's a really good case in the mutual wills. The resources around mutual wills, there's a few of them out there, but there's not a huge amount. But any case helps in these sort of situations, I think. So it's really wonderful that the judge went to the effort of providing such a thoughtful judgment for us all to sort of learn from. So that's a really good case, I think, to start off, particularly for our inaugural technical episode. So thank you for that. Yay.
And I think I did a relatively good job at presenting it in an objective way. I hope so. Anyway.
I think you did a great job, and in a nice, short, succinct manner. So good work.
So, Shell, family provision applications and disentitling conduct. Anybody who knows you, even your online presence, would know this is one of your pet, or maybe your favorite pet topic. You're a bit of a guru, an expert on this area, and certainly if I ever have a question and need to say, hey, what are the most 5 recent cases in this area, Shell, I'll email you because I know you'll be on top of it. So you're about to tell us about a recent decision out of the Queensland District Court in Queensland that discussed disentitling conduct, or the prospect of disentitling conduct in a family provision case. So what is it?
Thank you kindly. Yes, definitely absolute succession nerd in every which way, especially when it comes to disentitling conduct. So thank you for that, a little intro. So with the recent decision, it was of Hartley and Hartley. As Kate said, it was a Queensland District Court decision at the end of last year, in December, in fact. And it involved an applicant who was 49 years old. He was an adult son of the deceased and was excluded from his mother's will. So his mother had passed away 5 years prior to the judgment and had left 4 sons. Now, the deceased had also left a will that excluded this particular applicant and left 3 house properties and the residue between the other 4 children. The estate was worth about 1.2 million, so it wasn't particularly small, but ultimately left out the applicant. Now, the applicant was a particularly difficult background. He was on a disability support pension after resulting from an injury suffered in his 20s, and had lived in community housing and had no real assets. There was a range of accusations by the executors upon the applicant, in particular around disentitling conduct, which they said comprised of stealing from the deceased, hostility, exposing her to violence by drug associates, damaging property, physical domestic violence, and psychological stress and anxiety. So quite a collection of things. Now, with the deceased had actually left not only her will, but also a statutory declaration as to her reasons why she excluded the applicant from provision in her will. Now, the court ultimately decided that it was not satisfied the applicant's conduct was disentitling, and referred more to, quote, his lame duck status consequent upon his tumultuous childhood, physical, sexual and emotional abuse, exposure to drugs and drug-addicted reckless lifestyle, unquote. So it's quite an interesting case, and the reasons as to why the court came to that, I'll go through with you now. So as I said, the applicant himself was not of great means. The estate being $1.2 million, there was obviously a little bit of wiggle room in terms of making this a legacy for the applicant that the court decided to provide. Interestingly, the other brothers, the other siblings of the applicant, the deceased children, also weren't of great means themselves, many of which were on Centrelink, etc. And unfortunately, the background of the applicant in his growing up was particularly difficult. For example, he had been exposed to drugs at a young age. His mother had sold cannabis and had smoked it herself, and just had a lot of exposures perhaps children may be quite traumatized by in the early life. So those sorts of things were certainly part of what the court considered in terms of the applicant's background. So unfortunately, throughout his life, there was a number of incarcerations due to the drug violence and other issues that he had gone through. There was verbal abuse of the deceased by him and smashing of holes in the walls of some of the properties that she owned. There was allegations of him stealing bingo winnings and all these sorts of things, which was what was referenced in the statutory declaration. And the court actually found the applicant's evidence to be quite candid and fairly reliable in going through the judgment. And he was quite prepared to admit to probably taking a lot of the amounts that were alleged in the course of the matter, which I think was well received by the court generally as well. So the applicant, his long criminal history certainly played a part in how the court perceived his conduct toward the deceased and everything around. And the statutory declaration referred to having left him out of the will, including his girlfriend, who was also mentioned that the deceased didn't want to benefit from anything in her will. And the deceased had referred to the reason, well, one of the reasons being is that he had been given money to help himself out throughout the course of her lifetime, had purchased, he and the girlfriend, a vehicle. He was, at that time of the statutory declaration, allegedly addicted to the drug ice, and had also been in prison for his crimes, breaking and entering, drug possession, assault, had stolen allegedly $1,600 from the deceased during a lifetime, and all of these other things that obviously impacted her decision to make no provision for him. In support of that response to the applicant's case, there was also evidence from the deceased friends and sister about the conduct that the deceased had experienced from or as a result of her son's actions over the years. The applicant in his case had attempted to equate his behaviour as to that of a spendthrift or gambler, and the court ultimately did not agree with that, saying that it was the applicant's conduct was clothed in illegality as opposed to just recklessness. And whilst the conduct wasn't felt to be characterised as disentitling conduct, the court made an interesting comment purely that, I'll quote this, it said, I conclude that the applicant is not disentitled to adequate provision from the deceased estate. I think that a wise and just testatrix, having regard to the applicant's hopeless state and its genesis, should have made provision for the applicant in her will. And so that was ultimately the decision. And the legacy that the court ordered as provision for the applicant was $150,000. So I think in this particular case, it's not a small amount, but it's not also a very large amount, considering the estate's worth $1.2 million. And I think that, personally, I think that's probably a combination of things. One, that the other siblings also didn't have great means in terms of competing interests. And also that there was a genesis to the upbringing that the applicant had been exposed to. And, you know, I think that plays a big part. And of course, the applicant's evidence was mostly received well by the court as well. So it seems like he was able to make some appropriate concessions in the context of considering his case, which I think was probably a big part of that. I think at this stage, Kate, I've got to ask you, you know, in your work, obviously, you kind of see these sort of cases all the time. It's something that's constantly having to be discussed, even in a preliminary sense, from solicitors going, okay, we've got conduct doesn't matter in this.
Yeah.
What are your immediate thoughts on this case?
Well, first of all, I say the old stat dec to explain the deceased reasons. Yeah. That's a bit of an estate litigator's dream if you're for an applicant. Because invariably the stat decs are full of usually completely inadmissible things that aren't sustained by evidence, that can't be proved by any other evidence, that might be opinions of the deceased. And quite often they not only are they inadmissible as to the truth of them, they can actually say things that are easily disproven or easily shown to be just somebody's perception of something that happened, as opposed to the facts of actually something
what actually
that
happened. Yeah.
So just remember, a stat dec isn't evidence of the things that are in it. It's simply evidence. It's admissible as evidence as to the deceased reasons for not leaving somebody something in a will. But I am yet, and this is in nearly 28 years of practice, to see one where a statutory declaration or a statement of reasons of a deceased person actually helps the defence of a family provision application, and more often than not, it assists the applicant, in my experience anyway.
I think it's really interesting because a lot of people talk about statutory declarations or letters of wishes or whatever kind of terminology you want to use as a bit of a supportive mechanism. And I would love to believe it, but I don't necessarily agree for that reason, because every litigator I speak to talks about a statutory declaration, for want of a better phrase, becoming a bit of a shopping list of things to disprove in terms of supporting an applicant's case. So it's really like a double-edged sword, isn't it?
Yeah, because if you can, there was a really good example in a case from many years ago, and I can't remember what it's called, but one of the reasons given by a deceased person for cutting somebody out of a will was that on a particular night that person had tried to run them down and kill them in their car. And the applicant was able to prove that on that particular date that the deceased alleged, they were actually out of the country.
Golly, there you go. Yeah.
So as soon as an applicant can prove something to the contrary of what is asserted in a stat dec or a statement of reasons, it then just becomes, the deceased gets painted as somebody who is either delusional or just completely mistaken, or very one-sided, or a little bit like it was in this situation, or that you've got to keep coming back to that a court is not looking here to find blame or who's responsible for why an applicant might be a lame duck, but they are going to look behind the reasons. So the mother here, who had bent over backwards and provided a lot of assistance to the applicant during his adult lifetime, was also kind of the person who was in some ways responsible for him going down the path that he went. Now, it seems that his other brothers didn't go down that path or that same path, but that's quite common, that you can have people with the same upbringing and some go down a particular path and others don't. That's not necessarily their fault, or something in a family provision context that a court is going to assign fault to them for. That's the problem.
And I think it's really,
family provision is to cater for the lame ducks of this world. Unfortunately, every family who is on the other side of these cases hates that concept, but that is what they're for. That they're actually here. That family provision law is here to actually provide for those people who are in exactly the applicant in this case's circumstance.
Yeah. That's right. I mean, and in fact, even in this case, it referred to, there was a comment about the deceased having taken out an AVO or a restraining order against this particular applicant, but it was found that there was no such order against the applicant. So it probably didn't really help in that context. But you're quite right. And I think it's really hard with disentitling conduct and indeed estrangement cases, because you can't help but see a theme in these cases where the court is having to determine fault or attribution for certain, issues that have arisen in the context of these, the livelihood and what they need to consider. So blame and those sorts of things always end up coming into it in some way or another. Right or wrong, that's what tends to happen in these cases.
They do, but I actually think it's less, the blame and the court finding a blame is actually less. I think it's the parties want to point the finger at.
100%. Yeah.
That was the deceased's fault, or that's the applicant's fault. And the court is not going to be looking to find blame. The court is just going to be saying, well, these are the circumstances that we have. And how do we deal with that in the context of whether or not adequate provision was provided? So does it
disentitle? Does it break apart the obligation that stems from the whole family provision legislation perspective in the first place? Does that sever the connection or that or the genesis between the two? Is it severed? And that's ultimately the question that it ends up, broadly speaking, that's how it ends up having to be determined.
Yeah, very, very interesting questions. And as you know all of these cases, Michelle, very, very conduct sufficient to defeat an applicant's claim.
Yeah, very much. And I mean, on the statutory declarations, I don't know about you, Kate, but I've certainly been hearing a lot more conversation about the efficacy of those sorts of documents lately. And I think it was quite a good timing to see this case come up and go, oh, a statutory declaration, a gift that keeps on giving, and see what it has to, what kind of context can it offer. But I also have to say, I mean, this is something for you, Kate, with what you do in litigation world. When it comes to the evidence of an applicant, I think in this case, it really sort of pointed out that the candid nature of the applicant, or even the concessions he made, were well received. In terms of giving evidence in an applicant's case, do you think that's a really big key part to the success or perhaps failure, if you want to call it that, of these types of claims?
Absolutely, Shell. I mean, it's the main reason why I always say it's very, very difficult for anybody to give an advice on prospects or an advice on what somebody is likely to receive in a family provision application, because they are so, the cases do vary so much and depend so much on the personal views of a judge who's hearing it. And every judge is going to have different, come from a different perspective and have different views on family provision, and whether they might be generous or not generous, and whether or not a testator's freedom should be paramount or not, subject to those to the statutory requirements, of course. But as it might be said for all litigation, so much depends upon the view that a judge forms of the applicant in the witness box. And so it's really, really difficult somebody seeing all of the evidence play out in court to say what a judge might do.
I think that's exactly it, hey. And I mean, these sorts of cases just point that out even further. And if you really look at a lot of these cases, I did a paper on disentitling conduct and estrangement a couple of years ago, and just looking at those in a short succession of one another, that theme of the candid evidence provided by the applicant is not a bad thing. In fact, it helps the court really understand. And when you're making appropriate concessions, just gives more credibility to the worthiness of your evidence and whether the court will actually accept it or not. And I've seen cases there's not been one thing, they've been really particularly difficult, an applicant or something, and it's really damaged the success of their case. And I think from a lawyer's perspective, I think that's something we just need to prepare them for right at the beginning. Try to hold your ground to the nth degree is not necessarily going to help you. And going from there. But certainly from a planning perspective, I look at these cases and go, well, geez, is there any value in the stat tech? I'm not sure, kind of on the fence about it, but nothing seems to be putting me on the fence of the go for it side at the moment. It seems to be all like, no.
Yeah, I don't recommend them. And I recall Justice Alan Wilson, who retired from the Supreme Court a few years ago in Queensland, who was a leader of the bar for many years in our area of law, used to rub his hands together when he acted for an applicant and the estate came up with a statutory declaration with reasons. So he rubbed his hands together in glee.
There you go.
I think that's a pretty good indicator.
Yeah, I think you might be right. Well, look, I think we could probably talk on this topic for a while. We might have to hold over for another episode on that one. I'm sure I'll find another case to talk about that's juicy and for all the law nerds out there. But look, I think we might leave it there. What do you reckon, Kate?
Sure, Michelle. Now, we do want to let people know that we invite people to give us any questions via email. Our email is hello@theairwaves.com, and we're happy to discuss in future episodes any questions that people might have, just with the rider that, of course, we're not giving legal advice, and anything that we do say is of a general nature only. But we invite questions on anything to do with succession, wills, estates, trusts.
So yes, guys, please do send through cases of any sort that you want us to have a chat about or questions you want us to talk through. We'd love to hear from you guys. That email again is hello@theairwaves.com.
And of course, the citations for both of the cases that we've discussed today will be in the show notes.
They certainly will. So, all right, we're going to leave it there and we will start to plan our next episode. If you liked what we're doing, please do rate us on the app that you are using. We are available on Spotify and on Apple Podcasts, and of course through the Podbean app if you are a Podbeaner. But in the meantime, thanks so much for coming and joining us today, and we look forward to talking with you guys again on our next episode.
Thank you very much, everyone.
Thanks, guys. See ya.
Bye.